Hello, my name is Relisha Gabriel, acting for the accused Marshall Ike, a 14-year-old Torres Strait Islander boy. Your Honour, subsequent to Section 590 AA of the Queensland Criminal Code, I wish to make an application on the admissibility of evidence presented by the Crown on the basis of several grounds. The first issue is the nature of the confessions relied upon in the Crown's evidence with relation to my client's Indigenous background. I submit that the confessions obtained by police be excluded from evidence due to the occurrence of a phenomenon known as gratuitous concurrence. In the case of the Crown and Ananga, a Northern Territory case, Justice Foster explained in paragraph 414, most Aboriginal people are basically courteous and polite and will answer questions by white people in a way in which they think the questioner wants. He goes on to extend this definition to authority figures. Your Honour, I ask the Court to consider the impact this would have on the validity of the responses my client provided. The authoritative nature of both the officers and the social worker, considered from this cultural perspective, would have severely impacted the reliability of Mr. Ike's confession. Furthermore, I'd like to draw the Court's attention to the fact that my client had virtually no support throughout this process, which may have perhaps negated or limited the impact of this occurrence. Given the contents of these admissions, I submit that Mr. Ike's confessions were based on a cultural reluctance to displease, rather than because he actually disagreed or agreed with the questions asked. In the Crown and Lee, the High Court accepted the Christie discretion in terms of excluding evidence based on its unfairness. I submit to the Court that the facts of this case fall within the scope of the Lee discretion. The second issue is the conduct and actions of the police officers, both at the time of the primary confession and the subsequent recorded interview. Your Honour, I submit to the Court that the evidence gathered against Mr. Ike was done so in strict violation of the Police Powers and Responsibilities Act, hereby referred to as PPRA. The charges of 84 counts of breaking and entering and 1 count of stealing are indictable offences that fall within Section 98 of the Criminal Code. This attaches procedures and responsibilities in the interrogation process as outlined in Section 414 of the PPRA. Pursuant to Section 418 of the PPRA, my client should have been allowed to telephone a friend to inform them where they were or speak to a lawyer. Specifically, a prudent officer noting my client's background would have adhered to the procedures in Section 420. Pursuant to Section 420, the officer should have informed my client that legal aid would be contacted and allow him to speak to a support person. Furthermore, given my client's age of 14, Section 421 allows him to speak to a support person of his choice without being overheard. The social worker at the interview was chosen by the police and did not converse privately with my client. The interview should have been suspended until all these procedures could have been appropriately carried out. In cases where police act illegally or in improper ways to obtain evidence, the Court may exercise its discretion to exclude said evidence, provided it's in the public's interest. This was established in the Crown and Ireland and later reinforced in the High Court case of Bunnings and Cross, utilizing the Christie discretion. The objective test established in Bunnings and Cross set out the conditions for exercising this judicial discretion. The first condition of this test looks at whether the conduct resulted from a deliberate disregard of the law. The conduct of the officers clearly indicates this, given the substantial amount of PPR breaches which occurred in obtaining this evidence. There is nothing on the facts provided which excuse or justify this behavior other than the officers' blatant disregard for their legal obligations. The second consideration looks at how the evidence was collected and whether it affects the cogency, clearness, and lucidity of the evidence in question. It is clear to see, given my earlier submission on gratuitous concurrence and the accused's age and lack of legal or support personnel, that the legitimacy of the confessions is called into question. In most cases, it relies solely on the testimony of individuals who have already demonstrated a high disregard for the law, particularly given that in Section 435 of the PPRA, the interview itself was not even recorded in accordance to this. The third consideration looks at how easily the police could have obtained the evidence legally. There is nothing on the facts which suggests that the officers in question could not obtain my client's confession using the procedures in the PPRA. In fact, in some cases, doing so would have caused almost no difficulty. For example, the officer's failure to caution my client pursuant to Section 431, such as his right to silence. The fourth consideration focuses on the seriousness of the offense versus the seriousness of the unlawful conduct of the officers. Your Honor, it's true my client faces 84 counts of breaking and entering and 1 count of stealing, and I would not attempt to dissuade the court from the seriousness of this. However, it should be noted that the Crown's primary evidence in relation to these charges are in fact the confessions in question. Furthermore, given the reckless conduct of the officers and the resulting breaches of the PPRA, I would argue that the seriousness of the officers' conduct far outweighs that of the charges against my client. The final consideration looks at the intention of Parliament through the statute. Referring to the PPRA, it is clear that Parliament intended to limit police conduct in the gathering of evidence, with a reference to the purpose of the Act in Section 5. I submit that the officers in question have clearly breached this in relation to the conduct mentioned previously. Furthermore, an intention to specifically protect Indigenous people in these procedures, such as my client, could be conferred from the content of Section 420. In the interest of balancing expectations of public policy, I submit that the test in Bunnings and Cross has been sufficiently made out in which to invite judicial discretion. In the light of these gross violations, I make an application to therefore exclude the evidence presented by Crown under Section 130 of the Evidence Act. Should the court accept my submissions, I would ask the charges against my client be dropped, as the identification of the offender responsible for these 85 offences can no longer be established by police, as there is no admissible evidence in relation to this. The Crown has therefore failed to discharge its evidentiary burden. Thank you, Your Honour.